There's been a lot of news about Representative Gohmert's lawsuit against Vice President Pence regarding the counting of the votes of the presidential electors. Now, much of the reporting is wrong, but then so is much of what I found in the actual lawsuit. Rather than reviewing all the misinformation coming out of the news media, I went right to the lawsuit and found plenty of misinformation for this video. So we'll discuss that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. I am glad you could join me. I'm hoping you're finding these videos useful. They're valuable. 2021 looks to be a very interesting year, and I'm hoping you'll take this and you'll share what you're finding here with friends and family. Everything on the website is free to use and it is free to share. Head over to constitutionstudy.com, find out more, and let's engage with our communities. Hey, share this video, like it, subscribe to it, whatever you want on whatever media platform you're watching this or you're listening to. Let's share, let's get the information out. One thing I want to tell you, though, is you are not alone. I know it can feel like you're all alone in a sea of insanity, but you're not. So I've started a new program, and I want you to go over and check it out. It's called Constitution Scholars. Just go to constitutionscholars.com. You can sign up for free. That's right, you register. It's not a free trial. You don't need to put in a credit card. It is absolutely free. You sign up, and you can gain access to not only information from me and from other scholars, but you can meet other scholars as well. You can blog with them, ask questions, get answers, message them, become friends with them, share information. I really want this to become the community where the people who are interested in the supreme law of the land can get together and learn more about themselves and prepare themselves to not only recognize when their rights are being violated, but help teach others to do as well. So there's more information over there. Again, that's constitutionscholars.com. Check it out. If you have any questions, hey, let me know. I'll be more than happy to answer them. But with that, let's talk about Mr. Gohmert's complaint. Reading from Mr. Gohmert's complaint, quote, "These provisions of Section 15 of the Electoral Count Act are unconstitutional insofar as they establish procedures for determining which of two or more competing slates of presidential electors for a given state are to be counted in the Electoral College, or how objections to a preferred state are adjudicated that violate the 12th Amendment. This violation occurs because the Electoral Count Act directs the defendant, Vice President Michael R. Pence, in his capacity as President of the Senate and presiding officer over the January 6, 2021 joint session of Congress, to 1, to count the electoral votes for a state that have been appointed in violation of the Electors Clause, 2, limits or eliminates his exclusive authority and sole discretion under the 12th Amendment to determine which slate of electors for a state or neither may be counted, and 3, replaces the 12th Amendment's dispute resolution procedure under which the House of Representatives has sole authority to choose the president." Okay, there's a lot there, but let's get into this. First, the good news is, yes, he is right. Many of the provisions of 3 U.S.C. 15 are unconstitutional and therefore illegal and void. The bad news is Mr. Gohmert is claiming the Vice President has powers the Constitution does not delegate to him. Let's start with counting votes. He says, number 1, to count the electoral votes for a state that have been appointed in violation of the Electors Clause. Now, does 3 U.S.C. 15 direct the President of the Senate to count votes of electors that have been appointed in violation of the Constitution's Electors Clause? Well, 3 U.S.C. 15 reads, quote, "2 tellers shall be previously appointed on the part of the Senate and 2 on the part of the House of Representatives, to whom shall be handed, as they are opened by the President of the Senate, all certificates and papers purporting to be certificates of the electoral votes, which certificates and papers shall be opened, presented, and acted upon in the alphabetical order of the states, beginning with the letter A, and said tellers, having then read the same in the presence of the and hearing of the 2 houses, shall make a list of the votes as they shall appear from the said certificates, and the votes having been ascertained and counted according to the rules in this subchapter provided, the results of the same shall be delivered to the President of the Senate, who shall thereupon announce the state of the vote, which announcement shall be deemed a sufficient declaration of the persons, if any, elected President and Vice President of the United States, and, together with a list of the votes, be entered into the journals of the 2 houses." Whew. Love reading laws. All right, first of all, 3 U.S.C. 15 does not direct the President of the Senate to count ballots. 2 tellers from each house count the ballots. Does this violate the Constitution's 12th Amendment? Well, it says, quote, "The President of the Senate shall, in the presence of the Senate and the House of Representatives, open all the certificates, and the votes shall then be counted." See, the 12th Amendment states that the President of the Senate is to open the certificates from the states and that the votes shall be counted. It doesn't state who counts the votes or how those votes are to be counted. Since this is being done in a joint session of Congress and the law that Congress passed does not violate the requirement that the President of the Senate open the certificates, I do not see a constitutional violation here. Now, does 3 U.S.C. 15 direct the Vice President to count the votes of electors appointed in violation of the Electors Clause? Well, let's start with nothing in the Constitution gives the federal government any authority to question the decisions of the states regarding the appointment of presidential electors. Article 2, Section 1, Clause 2 reads, quote, "Each state shall appoint, in such manner as the legislature thereof may direct, a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress." If a state's legislature is, as the Electors Clause states, the sole decider for determining the manner of appointing electors, then where is anyone in the federal government granted the authority to question the appointments? The answer is nowhere in the Constitution. Now, we'll talk more about that when we discuss the dispute resolution in a few minutes. Since 3 U.S.C. 15 does not give any direction to the Vice President regarding which votes to count, well, that's strike number 1 for Mr. Gohmert. According to the complaint, 3 U.S.C. 15, quote, "limits or eliminates his, the Vice President's, exclusive authority and sole discretion under the 12th Amendment to determine which slates of electors for a state or neither may be counted." So next, Mr. Gohmert claims that the Vice President has the exclusive authority and sole discretion to determine which slate of electors may be counted. There's just one problem. Nothing in the 12th Amendment grants any discretion to determine which votes are to be counted. Quote, "The President of the Senate shall, in the presence of the Senate and the House of Representatives, open all their certificates, and the votes shall then be counted." That's it. No one in Congress is given the authority to question, much less decide, which certificates to open or which votes to count. So 3 U.S.C. 15 does not violate the Vice President's authority to determine the electors to count. It violates the authority of the state legislatures to appoint electors in whatever manner they determine. How does it do that? Quote, "Upon such reading of any certificate or paper, the President of the Senate shall call for objections, if any. Congress, including the President of the Senate, does not have the authority to object either to the electors or their votes." Strike 2 for Mr. Gohmert. But what about this dispute resolution? Well, his complaint says that 3 U.S.C. 15, quote, "replaces the 12th Amendment's dispute resolution procedure under which the House of Representatives has sole authority to choose the President." The 12th Amendment does not grant any authority to the federal government to resolve any disputes over presidential electors or their votes. Since the Constitution does not delegate to the United States the power to dispute electors, that power remains with the states. As the 10th Amendment states, quote, "The powers not delegated to the United States by the Constitution, nor prohibited by to the states, are reserved to the states respectively or to the people." If a state believes another state violated the Constitution in the manner of appointing electors, that state can seek a redress from the federal courts, as Texas did. The fact that Texas Attorney General Paxton ruined his argument does not mean the power devolves to the federal government. If you want to know more, I'll put a link to the article I wrote on Mr. Paxton's lawsuit. Furthermore, the 12th Amendment does not grant to the House of Representatives the authority to resolve disputes in the presidential elections. The House of Representatives only has the authority to choose a president if none of the persons receives a majority of the votes of the electors appointed. as the 12th Amendment states, quote, "The person having the greatest number of votes for president shall be president if such number be a majority of the whole number of electors appointed. And if no person have such majority, then from the persons having the highest number not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president." That makes strike number 3 for Mr. Gohmert. However, since this is not a game, we're not done with Mr. Gohmert's lawsuit yet. Quote, "Section 15 of the Electoral Count Act unconstitutionally violates the Electors Clause by usurping the exclusive and plenary authority of the state legislatures to determine the manner of appointing presidential electors, and instead gives that authority to the state's executive. Similarly, 3 U.S.C. 5 makes clear that the presidential electors of a state and their appointment by the state executive shall be conclusive." All right. This argument is a little more difficult to untangle, so stick with me. Let's start with 3 U.S.C. 5. Quote, "If any state shall have provided by laws enacted prior to the date fixed for the appointment of the electors for its final determination of any controversies or contests concerning the appointment of all or any of the electors of such state by judicial or other means or procedures, and such determination shall have been made at least 6 days prior to the time fixed for the meeting of the electors, such determination made pursuant to such law so existing on said date and made at least 6 days prior to the said date time of meeting of the electors shall be conclusive and shall govern in the counting of the electoral votes as provided in this Constitution, and is hereafter regulated so far as the ascertainment of the electors appointed by such state is concerned." Whew. Okay, contrary to Mr. Gohmert's complaint, 3 U.S.C. 5 does not state that a state's executive has exclusive authority to resolve controversies regarding the state's presidential electors. It states quite clearly that state law is conclusive, as long as that law was passed at least 6 days prior to the date the electors are appointed, which, by the way, is Election Day. If the state legislature created a procedure whereby a controversy over the state's electors is resolved by the state's executive, that is part of determining the manner of appointing electors. However, that is not a requirement of 3 U.S.C. 5. So now let's deal with the 3 U.S.C. 15 question, and I apologize, but this is a little convoluted. Quote, "But in case there shall arise the question which of 2 or more such state authorities determining what electors have been appointed, as mentioned in Section 5 of this title, is the lawful tribunal of such state, the votes regularly given of those electors and those only of such state shall be counted, whose title as electors the 2 houses, acting separately, shall concurrently decide is supported by the decision of such state so authorized by this law." All right, here's where things get really constitutionally messy. If there's a situation where 2 or more state authorities submit certificates of votes for their presidential electors, what is Congress to do? What happens if the state laws to resolve controversies mentioned in Section 5 either don't exist or are not followed? Section 15 claims that the power to decide which slate of electors to count devolves to the 2 houses. Which 2 houses? Well, based on the context, it appears to be the 2 houses of Congress. But as we've already seen, Congress has no legal authority to resolve disputes about presidential electors. So this cannot be legal. Continuing, quote, "But if the 2 houses shall disagree in respect of the counting of such votes, then, and in that case, the votes of the electors whose appointment shall have been certified by the executive of the state under the seal thereof shall be counted." The part that Mr. Gohmert challenges here is the situation where the 2 houses of Congress cannot agree on which slate of electors they will support in their violation of the Constitution. See, Mr. Gohmert is correct that the federal government placing the determination in the hands of the state executive violates the Electors Clause of the Constitution. However, by that point, Congress has already violated the Constitution by meddling in controversies in which it has no legal authority. If the members of Congress are willing to violate their oaths to meddle in state business, why would anyone be surprised that they continue to violate their oaths of office if both houses cannot agree? Now, what should happen if 2 or more certificates arrive from a single state? Well, since only the certificate that was created following the state law is valid, it is the only one that should be counted, as stated in 3 U.S.C. 5. Now, if that cannot be determined, then the state has not submitted a valid certificate, so their electors have not been legally appointed. And since the electors were not legally appointed, the total number of electors appointed would decrease by that number, thereby changing the number of votes needed for the majority. From the 12th Amendment, quote, "The person having the greatest number of votes for president shall be president if such number be a majority of the whole number of electors appointed." Now, after all that, what does Mr. Gohmert ask the court to do? Quote, "Accordingly, plaintiffs respectfully request this court to issue a declaratory judgment finding that A, Section 5 and 15 of the Electoral Count Act, 3 U.S.C. Sections 5 and 15, are unconstitutional because they violate the 12th Amendment of the U.S. Constitution, Article 2, Section 1, Clause 1, and Amendment 12 on the face of it, and further violate the Electors Clause. While there are parts of Section 15 that are unconstitutional, nothing in Section 5 is. At best, the court could find that the objection and dispute mechanisms in Section 15 are unconstitutional, but that doesn't really help Mr. Gohmert's apparent cause. Quote, B, that Vice-President Pence, in his capacity as President of the Senate and presiding officer over the January 6, 2021 joint session of Congress under the 12th Amendment, is subject solely to the requirements of the 12th Amendment and may exercise the exclusive authority and sole discretion in determining which electoral votes to count for a given state, and must ignore and may not rely on any provisions of the Electoral Count Act that would limit his exclusive authority and his sole discretion to determine the count, which would include votes from the slate of Republican electors from the contested states." Okay, all members of government are subject to the Constitution, including the 12th Amendment. However, the Constitution does not give the President of the Senate the authority or discretion to determine which votes to count. The only thing the Constitution grants to the President of the Senate is the power to collect and open certificates. Quote, C, that with respect to competing slates of electors from the state of Arizona and other contested states, the 12th Amendment contains the exclusive dispute resolution mechanism, namely that, 1, Vice President Pence determines which slate of electors' votes count, or neither, for that state. 2, how objections from members of Congress to any proffered state of electors is adjudicated. And 3, if no candidate has a majority of 270 electoral votes, then the House of Representatives, and only the House of Representatives, shall choose the president where, quote, the votes in the House of Representatives shall be taken by state, the representation from each state having one vote, U.S. Constitution Amendment 12. As we've already seen, the Constitution does not grant to the Vice President the authority to determine which votes to count. Neither does it provide any language allowing for members of Congress to object to the electors. And with only 2 candidates receiving votes, the only way the choice for president would devolve to the House of Representatives is if there is a tie in the electoral vote. Quote, D, that with respect to the counting of competing state slates of electors, the alternative dispute resolution procedures or priority rule in 3 U.S.C. 15, together with its incorporation of 3 U.S.C. 5, shall have no force or effect because it nullifies and replaces the 12th Amendment rules above with an entirely different procedure. Because Congress has no authority to dispute appointments of electors, I agree. Sections of 3 U.S.C. 15 are void and have no force. However, 3 U.S.C. 5, while it is technically redundant, does hold up under constitutional review. Since Mr. Gohmert is incorrect in his claim that 3 U.S.C. 5 places the ultimate resolution of controversies in the hands of the state executive, his request here is moot. See, to me, this appears to be yet another attempt to twist the Constitution to meet one group's political objectives, specifically here the re-election of President Trump. Now, while the Texas lawsuit at least had merit, it was buried beneath an avalanche of political agendas. Mr. Gohmert's gambit to get the federal judiciary to ignore the actual language of the Constitution to get the political outcome he desires does not even rise to the level of merit. It has justly died the ignoble death it deserved. I only hope the American people and the citizens of Texas see this lawsuit for what it is, a naked violation of the Constitution for political advancement. Does that help clear up some of the confusion about what's been going on with Representative Gohmert's lawsuit? I know there's been a lot of stuff in the news, and there's a lot of misinformation in the news. It is wrong. It is plain and simple. If we read the Constitution, if we read what's actually there, not what we want to be there, we see very simply the federal government, the United States, has absolutely zero authority to object to deal with controversies, or have anything to do with the actual votes of the electors or how those electors are appointed. That rests solely within the states, which brings up a very important point. This mess is our fault. Why? Because we allowed our state's elector process to be corrupted. Because they're open to fraud, to abuse, to manipulation, and we, the people, did nothing about it. This is nothing new. There is evidence that has already become public that shows, if not actual fraud, at least enough to question the validity of the vote. And our states did little. They didn't do nothing, but they certainly didn't do very much. Oh, sure, there were some politicians that were out in the media. That means nothing. There were even some that had some hearings. Okay, what are you doing about that? I've been reviewing some of what's went on in the hearings in Georgia, and there's another one of my articles that I'm going to be writing. We, the people, did nothing. What are we, the people, going to do? Not in Washington. The day before I recorded this, there were people storming the Capitol because they didn't like that the Vice President and the Congress were not going to violate the Constitution to fix the problem that were in their states. Tell me, where are the protests in the states? Where are the state legislatures holed up in their office, quaking in their boots because the people have said, we've had enough? You will follow our laws or you will be fired. Not violence, removed, impeached, recalled, or simply not voted for. Where? I don't see it. If you are upset with the presidential election, and I believe most of Americans are in one form or another, the problem is ours because the election is handled by the states and we have done squat to deal with it. So if you want to take a cue from history and say, never again will we have such a disaster of a presidential election, the time to start is now. And it's not in Washington, D.C., it's in your state capital. It's at the office of your state representative and your state senator or your state assemblyman or whatever they call them. It's time for you to get in their face and demand they do the job they were hired for, that they follow the laws we've put over them, and that if they won't, we will make sure they get fired. We will follow the law and make sure they lose their job. Because until those in our state houses are more afraid of us than of those in their political party, 2020 is just the beginning of the banana republic of the United States of America. Now, if you want to learn more, if you want to find out more, again, head to the Constitution Study. I hope you find these videos helpful. If you want to participate, if you're ready to go beyond just listening and you actually want to get involved, head to constitutionscholars.com, sign up for your free account, check it out, go through the library, look at the classrooms, look at the classes that are available, look at the communities, get involved with the communities. I'm going to start setting up groups for different states where I've got scholars that are going to work on state issues. So please do that. Check out scholars.com. And most of all, if you found any value in what we've been doing here today, I hope I'll see you again the next time at the Constitution Study.
There's one thing you have to know wherever you make your stand.